There will now be an opportunity for silent prayer or meditation. Please be seated. The Secretary will read the order.
Debate on vote 22, Office of the Chief Justice and Judicial Administration.
I now call to the podium the Honourable Minister of Justice and Correctional Services. Honourable Minister.
Honorable Chairperson, Ministers and Deputy Ministers, Honorable Members, distinguished members of the Judiciary, heads of professional law bodies, distinguished guests, ladies and gentlemen, allow me as I open this important debate to express my profound gratitude to our Chief Justice Mogoeng, whom I had the opportunity to meet ahead of today's budget vote. I look forward to his judicious guidance and wisdom and that of his leadership as we tackle the tasks ahead of us. I will therefore be engaging regularly with the Chief Justice and the judiciary on matters that are important to the judiciary and the courts in general. We have agreed to meet regularly to discuss matters of common interest. In his State of the Nation address, the Honorable President Ramaphosa emphasized the importance of our people's dream of South Africa that espouses our collective aspirations. In he sought to remind all of us that the South Africa we have falls short of the ideals our people aspire for, and for which many paid the supreme price. This year marks the 56th anniversary of the Rivonia trial, when Nelson Mandela and his co-accused persons, namely Leon Bernstein, Dennis Goldberg, Arthur Goldrich, Bob Happel, James Kanta, Ahmed Katrada, Nelson Mandela, Gavin Mbeki, Raymond Mhlaba, Andrew Mlangeni, Elias Mtsaledi, and Walter Sisulu stood trial in what had become known as the Rivonia trial, named after one of the suburbs of Johannesburg. The case was heard before Judge President Quartus de Wet, then the Judge President of the Transvaal Provincial Division of the Supreme Court. Leading the prosecution was Dr. Percy Hunter, then Deputy Attorney General of the Transvaal. Mandela, Sisulu, Mbeki, Mutwaledi, Mlangeni, and Goldberg were found guilty on all 4 counts of high treason. Nelson Mandela was sentenced to life imprisonment and served most of his 27 years and 8 months in Robben Island. Amongst the defense team that represented the accused persons was Arthur Chaskalson, who went on to become the first president of the newly established Constitutional Court before it was merged with that of the Chief Justice of the Republic of South Africa. The prosecutors of Nelson Mandela never harbored even the most remotest idea that his long walk to freedom will in fact be a journey of a triangle, from Robben Island to the Union buildings, and to the global stage that the United Nations proffered. It was on 11 November 2009 when the United Nations adopted a resolution by consensus that the date of birth of our first president of the Democratic Republic of South Africa will be recognized internationally for his remarkable contribution to promoting world peace, resolving conflicts, and promoting race relations, human rights, and reconciliation. Since from the year 2010, the International Mandela Day has been celebrated worldwide as the gesture of goodwill on which people of the world are encouraged to contribute 67 minutes towards humanity and making the world a better place. We as a country have come a long way. Today, things have changed. South Africa is a constitutional democracy.
Honourable Minister, I'm sorry to disturb you. Members of the gallery, you cannot take photos, flash photography. Especially those of the media should be aware. No flash photography are allowed in the chamber. because it's a distraction to the speaker at the podium and also to the members. Continue, Honourable Minister.
Today, things have changed. South Africa is a constitutional democracy, and the outlook of our judiciary and this democratic parliament has changed from what it was then, and represent largely the demographics of the South African population. We have had partial fulfillment of the ideals that were so eloquently articulated by President Mandela during the Rivonia trial. As attested by our recent national and provincial elections that ushered the 6th administration and our current parliament, our fledgling democracy has attained full maturity and is in safe hands of our democratic parliament and capable executive, under the watchful eye of our independent judiciary. Notwithstanding the strides we have made, the ideal for which Mandela lived and was prepared to die will be fully realized only when South Africans live together in harmony and with equal opportunities. This will be possible once we have been able to reverse the devastating legacy of the Land Act of 1913, the Native Trust Land Act of 1936, and the Group Areas Act of 1950, and other racially based laws that deprive the majority of the right to land. In the State of the Nation address of the 20th June 2019, the President Cyril Ramaphosa reflected on the progress we've made to cure our country of the corrosive effects of corruption and pursuit of the ideals and values of our Constitution. The judiciary, as an independent arm of the state, is an indispensable weapon in the fight against corruption, as in the constitutional democracy similar to ours. I have therefore deemed it fit that I dedicate today's debate of the Office of the Chief Justice to our case for a democratization of land ownership and the significance of a well-grounded jurisprudence towards the attainment of land justice in this country. It is in this context that we envisage a much broader dispensation than the current Land Claims Court for the full implementation of the Section 25 of the Constitution. The Interministerial Committee led by the Honorable Deputy President Mabuza is seized with this matter. The Land Court Bill we envisage will address the current challenges confronting the Land Claims Court, including the appointment of permanent judges in this important court. We will engage with the judiciary in this respect. It is not a mere coincidence that the Office of the Chief Justice was proclaimed as a department in the very same year that the United Nations declared the 18th of July as an International Mandela Day. But it is of fundamental significance in the life of our democracy. It is in this spirit that I believe that today's debate will not only be inspired by the resounding speech of Madiba during the Rivonia trial, but also our collective duty to build a judicial system that is consistent with our Supreme Constitution and a better world. The society envisaged in the National Development Plan, Vision 2030, in which poverty, unemployment, and inequality will be banished into history, remain the cardinal compass of our endeavors towards its attainment. Here today, we are looking into the realization of those dreams and aspirations of our people through the prisms of justice. Important to our debate today is the acknowledgement of the NDP of its significance of progressive jurisprudence that is required to complement and guide the efforts of the executive and the legislative branches of the state in transforming the state and society. By enjoining us to heal the divisions of the past, the Constitution demands of not to be indifferent to the challenges of poverty, inequality, unemployment, as espoused in the NDP. It is in this context that the judiciary has an indelible role in the advancement of radical socio-economic transformation to realize those transformative ideals to grow South Africa together. 25 years after the advent of our constitutional democracy, we remain committed to the vision of a non-racial, non-sexist, democratic, and a prosperous South Africa. This has also found expression in the composition of the judiciary, where out of the total numbers of 251 judges in the courts, 166, more than half, are black judges, and 97 women. In contrast, in 1994, the judiciary comprised of 165 judges, of which only 3 were black males, 2 white females, and no black female judge. However, much still needs to be done to ensure that our judiciary reflects the gender composition of the South African population. I am looking forward to participating in the Judicial Service Commission, and certainly so with other members of this august house who have been appointed to serve in this esteemed body, to continue with the important task of transforming the judiciary. We are similarly accelerating the transformation of the legal profession, which remains an important feeder to the judiciary. Let me at this point thank all the honorable justices who responded to the call of national duty and came to lead various commissions of inquiries, assigned the magnitude tasks of probing the allegations outlined and published in various terms of references of the commissions. The people of our land are indebted to Deputy Chief Justice Raymond Zondo, who amid his busy schedule at the Constitutional Court has stepped in to lead the commission to investigate allegations of state capture, corruption, and fraud in the public sector, including organs of state. In the same vein, we extend our gratitude to Justice Mpati, who chairs the commission on the allegation of impropriety regarding the Public Investment Corporation, which is still underway, and other justices who sacrificed their well-deserved retirement to respond to the call of duty. The South African judiciary has demonstrated its agility and prowess in dealing with cases brought before courts. Jurisprudence of the Constitutional Court continues to guide the executive and the legislative branches in exercising their distinctive constitutional mandate. Our organ of state, of which the Office of the Chief Justice is part, have constitutional mandate and obligation to assist and support the courts to ensure their independence and effectiveness and impartiality. It is important that we celebrate and deepen the doctrine of the separation of powers and the independence of the judiciary, which underpins our constitutional democracy. Each of the 3 arms of the state has its distinctive role, which it must exercise within the confines of the Constitution. I've been appraised of the work undertaken by the 5th administration on the project of a judicial governance and court administration, and will be approaching cabinet soon to get guidance in taking the process forward. The work of the OCJ in supporting the judiciary contribute towards Chapter 14 of the NDP, relating to the promotion and accountability and the fight against corruption. In support of the government's unwavering commitment to building a conducive and enabling environment for the effective functioning of the courts, the administrative functions and staff attached to the superior courts were transferred to the OCJ, with effect from 1 October 2014. This transfer also included a budget of about 1.5 billion, which was transferred from the Department of Justice and Constitutional Development to the OCJ. Of particular importance is that from 1 April 2015, the OCJ received its separate budget allocation on Vote 22. An amount of 7.38 billion is allocated over the current medium term and expenditure framework. This represents an average growth of 9.8% year on year and reflects the priority that is given to the OCJ. The growth reflected in the figures above is mainly to sustain the current level of service in the superior courts and support the judiciary. The budget of the OCJ consists of 3.84 billion for voted funds and 3.54 billion for judges' remuneration, which is a direct charge from the National Revenue Fund. The core function of the OCJ are allocated a total of 82.2% of the total budget. We are liaising with the President and the Office of the Chief Justice for a date in the near future for the official opening of the seat of the Mpumalanga High Court, with a delight to a very eye and exhibit magnificent architecture. An efficient court system is a paramount of the importance to access to justice. I've already alluded to the modernization project when I presented the policy budget statement of the Department of Justice and Constitutional Development. in respect of the superior courts, in particular the OCJ, continued with the development of the e-filing solution, which will be rolled out during the 2019 and 20 financial year. It is a great honor to represent the budget policy statement of the Office of the Chief Justice, vote number 22 for the financial year 2019-2020. I also want to convey our profound gratitude to the chairperson of the portfolio committees, entire committee for their continued support and guidance. A special word of thanks goes to the Office of the Chief Justice. Before I conclude, let me pay tribute to the Constitutional Court Judge, Honorable Justice Edwin Cameron, who will be bowing out of active service for his profound contribution to our constitutional jurisprudence. Justice Cameron is a renowned activist and one of the pioneers in the early development of our jurisprudence. The Glen Vista versus the President judgment remains a hallmark judgment for which he will be remembered. Let me take this opportunity to reaffirm our commitment to the strong and independent, effective judiciary. It is a requirement for a healthy and a stable democracy. It is a great honor to present the budget policy statement of the Office of the Chief Justice, OCJ, vote number 22 for the financial year 2019-2020. Thank you very much.
Thank you, Honourable Minister. The next speaker will be Honourable Magwanishe.
Thank you very much, Honorable House Chairperson.
Honourable Magwanishe, before you continue, there's an honourable member who is on his feet. Why are you rising, honourable member?
I'm rising, Deputy Chair, on the point that it's a requirement by law that we should be furnished with documents that states the name of the speakers and the time frame and where they come from. Thank you.
No, it's not a requirement of law. That's something, it's strange. Can we just make it simple, honourable members? May we just request the service officers to distribute the speakers list? That's all. Continue, honourable member.
Thank you very much, Honorable House Chairperson. Minister of
Continue, honourable Magwanishe.
Minister of Justice and Correctional Services, Honorable Ronald Lamula. Deputy Minister of Justice and Social Development, Honorable John Jeffries. Deputy Minister responsible for Correctional Services, Nkosi Phathekile Holomisa, Delizindaba. Ministers and Deputy Ministers present. Members of the Judiciary present, honorable members, Secretary General of the Office of the Chief Justice, members of the legal fraternity, distinguished guests, ladies and gentlemen, good afternoon. The Office of the Chief Justice presented its annual performance plan and its budget for 2019 MTEF to the committee on 5th July 2019. The committee raised a number of concerns that the Office of the Chief Justice could not respond to, as it would not be appropriate for officials to speak on behalf of the judiciary on matters that fall within the judicial competence. Although the Office of the Chief Justice is likely to provide the Chief Justice and the heads of courts with a report of the meeting, the committee would like to engage with the judiciary on issues of mutual interest regarding the functioning of the justice system. In the absence of a formal mechanism to guide interaction between Parliament and the judiciary, the committee agreed to ask the Speaker to arrange a meeting with the Chief Justice and the heads of courts. The committee is aware that the judicial governance and court administration model has been in the pipeline for some time. A committee requests that all stakeholders work together to finalize the model so that we can move forward. In the absence of the court administration and judicial governance model, the judiciary has decided to account directly to the nation. The South African Judiciary's Annual Report 2017-2018 contains valuable insights about developments within the judiciary and some statistics relating to the superior courts. The judiciary also posts information about reserved judgments on its website. The judiciary's Annual Report 2017-2018 does provide some statistics relating to the case finalization in the superior courts, but the committee notes that there is a gap in the case of the magistrate courts. For some years now, with the exception of statistics relating to the number of backlog cases and conviction rates, there has been little information available about court performance in the magistrate courts. These courts are serviced by the Department of Justice and Social Development, and they hear a majority of cases. The committee welcomes the minister's announcements that legislation will be introduced soon to allow for the permanent appointment of judges of the Land Claims Court. Until now, this court has been served by acting judges. We support a single judiciary as envisaged by Section 166 of the Constitution. The committee understands that a lower courts bill is at an advanced stage. There have been reports that judicial officers are experiencing difficulties in accessing tools of trade, especially law reports and other library materials. As our society becomes increasingly litigious, the workload of our courts has grown. Increasingly, IT modernization and digitization are seen to provide a way to assist our courts to keep on top of demand. We note the rollout of the ICT master plan systems. This promises to improve efficiencies in the court administrative processes. Specifically, the e-filing project will be rolled out in the superior courts in the medium term. The committee would like to learn more about the scope and progress of the project and will engage with the Office of the Chief Justice on this. There are worrying reports about lack of security at our courts. The committee asks that the Office of the Chief Justice provide it with a full report on this regard. The committee, having considered the budget vote 22 of the Office of the Chief Justice and Judicial Administration, support it and recommends that it be approved. I thank you.
Thank you, Honourable Member. The next speaker is the Honourable Breitenbach.
Thank you, Mr. Chair. Chairperson, honourable members, the Office of the Chief Justice has many and important responsibilities and is still a relatively new office with an expanding footprint. It has taken over many responsibilities from the Department of Justice, and this has brought many challenges. The OCJ supports the judiciary in contributing to Chapter 14 of the National Development Plan by accelerating reforms in a judiciary-led court administration, ensuring an efficient court system, reducing court administration inefficiencies, ensuring judicial accountability, and providing training to the judiciary. But as with most things, this onerous set of responsibilities does not come without problems. For some time now, the Democratic Alliance has raised in the committee the issue of a lack of meaningful information, the reporting on which has either been abandoned or has fallen between the cracks. The judiciary has effectively taken over the function of court administration, yet they do not report on how well or how efficiently the courts are working. This information cannot be obtained from the Department of Justice, since the function now resides with the judiciary. The information is not reported on by the NPA, because the function now resides with the judiciary. The end result is that as a committee we are unable to exercise oversight over one of the most important issues in the criminal justice cluster: how well are the courts working? We know just from everyday experiences of our citizens that they are not working well at all. Court hours continue to decrease. Statistics on how many cases are enrolled and finalized continue to shrink, while crime is rampant and South Africans are exposed to a violent, crime-ridden society with nowhere to go. We know that the number of cases reported to the police is exponentially higher than those that get through the system to some conclusion. Yet it is near impossible to glean the information necessary to determine how well the courts are working. This is an unacceptable state of affairs and it must be remedied. Courts are supposed to sit for 4.5 hours daily. There are no courts in South Africa that sit for that time. Very few courts start on time, most finish early. It is time to enforce court hours, to ensure that court sits for full days and dispatch with many more cases than is currently the case. There should be consequences for such shockingly poor productivity. The battle against crime and corruption cannot be won unless the courts sit and sit productively. That being said, judges and magistrates, prosecutors and the public are subjected to the most unappetizing conditions at courts around the country. The buildings are in need of maintenance and repair. The working conditions are quite shocking. The air conditioning in the North Gauteng High Court has not worked for the past 15 years, with temperatures inside the courts often rising above 38 degrees in the summer. Of course, no one can be expected to be productive in these conditions. This is the case all around the country. It is simply unacceptable. Judges are required to produce high-quality judgments in matters with increasingly complex facts, with little or no support. They have little in the way of administrative support, a huge shortage of research support, and are expected to produce high-quality work on a shoestring budget in less than agreeable working conditions. Generally speaking, they have done this, but it's just a matter of time before it becomes impossible. Last year, after a plea to the Deputy Minister, judges received a batch of long overdue law reports, which took them to March 2019. Since then, they have again not received them. With no access to South African law reports, judges struggle to remain abreast of developments in the law. Earlier this year, the intranet serving the courts was down for weeks, making it impossible for the court to send or receive emails, bearing in mind that in the electronic age, heads of argument and other essential documents are often served via email. You can imagine the chaos that ensued. Outstanding reserved judgments remain a perennial problem, with a few judges having outstanding reserved judgments that are not just months, but years late, one as long as 6 years. In the Eastern Cape High Court, the oldest outstanding judgment is 17 months. In the North Gauteng High Court, the oldest outstanding matter is 20 months. In KZN in Pietermaritzburg, the longest outstanding matter is 74 months. Somebody is waiting 74 months for a judgment. It still hasn't been delivered. KZN in Durban, 48 months, and in the Western Cape, 26 months. This is clearly not a state of affairs that can continue, and some sort of discipline needs to be brought to bear, and consequences must ensue for this type of inaction. It is something that the JSC needs to attend to urgently. But despite these problems, we have a lot to be grateful for. The judiciary is the one branch of the criminal justice system that was never captured. They held the line against state capture and successfully defended and enforced our constitution. The problems we will solve, and our judiciary remains an institution of which we can justifiably be proud. I thank you.
The next speaker is the Honorable Mulawutsi.
Madekwana, Chairperson Kolibu Amuzurajuro, no Rumelisa Mirado, Narushak. Remember, EFFR ko tickets and no supporter, Mugaganyagwa Mawoyua, Unako Umberwa, Gaba Officer Chief Justice. Chairperson, the economic freedom fighters takes the importance of the independence of judiciary very seriously, and we will guard that independence with all we have. The courts have often been the last line of defense for the people of this country, whose future was put at risk by a group of self-serving leaders whose only interest was to line up their pockets and to steal from the state resources that belong to the public. One of the very few good things after 1994 was the proclamation of the Office of Chief Justice as a department. This is to ensure an independent judiciary-led court administration system in order to fully realize the judiciary institutional independence in line with the Constitution and Superior Court Act 2013. For this reason, there must be no reason whatsoever that the Office of Chief Justice should at any time fail to do its work because of shortage of funds. If we are serious about the independence of judiciary, we must begin to ask ourselves some questions seriously. If the judiciary is dependent on Parliament and the Minister of Finance for its budget allocation, what will then happen when the Parliament and the Executive go on the wrong side of the law, as they are beginning to be with the Office of the Public Protector? What happened when they refuse to finance the Office of Chief Justice sufficiently? We know that allocation of budget is a deeply politicized thing in this country. when Tulima Donsela wanted money for investigation of Mr. Zuma on state capture, Mr. Jamnadas Godan gave her the money without questions. Now, when Advocate Wusisiwe Mkhwebane wants money to conduct serious investigation, she's denied that money. Mudzulachidulo, rine ri khou dovha ra humbela uri arali zwi tshi konadzea hevha muhaṱuli muhulwane wa ofisi ya vhatshutshisi ya majaji arali vha tshi humbela budget kha vha fhiwe gavhelo ḽavho vha finance vha si no hanedza. Chairperson, while we upload the work done by the Office of Chief Justice, we are not quite pleased with the time it takes to fill some of the vacancies in our courts, including the Constitutional Court. Chairperson, to preserve jurisprudential coherence, the Constitutional Court must have all the judges of the Constitutional Court appointed permanently. And where vacancies occur, it must never take more than a year to fill those vacancies. For this reason, we must introduce measures to strengthen the Judicial Service Commission to ensure the adequate and the speedily filling up of judicial vacancies, the training of judges, and the qualitative transformation of the judiciary beyond numbers and demographics. Minister, rine ba EFF ri khou dovha ra ri zwi nga ri takadza vhukuma arali ri tshi vhona vhulamukanyi hafha na Afrika Tshipembe arali vhu tshi shumiwa nga Tshiafrika uri vhathu vha tshi vha swikelele dzi khothe dzashu nga luambo lune lwa vha lwa havho lwa ḓamuni. There is a general perception in society that justice is only the preserve of the rich and powerful, and that it's only the poor that get condemned to jails, while the rich can buy their way out of accountability. Ri khou ṱoḓa hafhu futhi mudzulatshidulo uri vha vhulamukanyi uri vha kone u swikelela hune vha thusa zwishayi hanengei mahayani uri hoṱhe hoṱhe vhulamukanyi vhu kone u swika hu si no konḓelwa. Ri dovhe hafhu ri ri nga lutamo lwashu a ri khou vha na thembo khulu kha traditional court bill, ndi mulayo une wa laula dzi khothe dza mahosi ngei mahayani uri na u ḓo kona u thusa vhadzulapo vhoṱhe vha Afrika Tshipembe na. At the practical level, we need the Chief Justice to be more hands-on in the supervision of the lower courts. That's the regional courts and the district magistrate court. It is the level of lower courts that most injustices happen, where accused people are kept in jail for years without trial, and where magistrates sometimes act with impunity in cohort with corrupt local government officials. Chairperson, one of the most important functions that must be performed by the Chief Justice is the training of judges and magistrates to interpret the law without regard to political manipulation. One of the lowest points of judiciary was when the judge recently quoted a political slogan of New Dawn when delivering his judgment and made unfounded conclusion about alleged corruption at some state entities based on nothing but public sentiment. Our judges must focus purely on law and not to be swayed by populist right-wing elements who want to capture them out of society. Minister, the other issue we are concerned as EFF is the issue of the establishment of the single judicial system in terms of Section 166 of the Constitution. Also, we have the concern about the court directives in Gauteng high courts, where Judge President introduced that all matters which are scheduled beyond the 31st March 2020, they are being scrapped out of the roll. We have plus 6,000 rough files which are outstanding and is affecting the litigants who are claiming against the Road Accident Fund and the Minister of MEC of Health in Gauteng and PRASA as a defendants. The other concern is the court infrastructure and the maintenance. Most of our courts, they are outdated in terms of renovation. Some, the lifts are not working and the air conditioner are not working. We would like the minister also to push the Minister of Infrastructure and Public Works to speedy fix the issue of the building. So lastly, we want to appreciate, Minister, of your announcement of land claims court of establishing a legislation to appoint a permanent judges on that court, because that's crucial when we are focusing on the expropriation of land without compensation. The EFF support this budget. Thank you, Chairperson.
Thank you, Honourable Member. The next speaker is the Honourable Singh.
Thank you very much, Honourable Chairperson. Honourable Minister, may I first on behalf of the IFP congratulate you on your appointment. The others are old hats, so I won't congratulate them. Honourable Chairperson, the Office of the Chief Justice is critical to the functioning and independence of the judiciary and a principal check and balance against the unconstitutional abuse of power by the state. What is worrisome, though, is that institutionally there has been no evolution regarding the institutional model despite the proposal made by the judiciary, which was originally submitted 6 years ago in 2013. Questions must be answered by the ministry in this regard. And here I refer to the transfer of the magistracy from the Department of Justice to the Office of the Chief Justice, which I believe, and the IFP believes, will do a great deal to ensure such independence. And even though there has been some engagement and talk of a single judiciary, this will remain nothing but a pipe dream unless and until legislation is enacted, placing the magistracy under the umbrella of the Office of the Chief Justice. Chairperson, review of the regulations on judges' leave is another serious point of contention, which we believe is set in opposition to the constitutional prescripts as regards judicial independence. I am aware that this issue has been raised previously, pertaining to the minister's role of approving leave for judges. Chairperson, in my humble opinion, this sets out the wrong signal, namely that the executive oversees the judiciary and thereby is at odds with and undermining judicial independence. The minister should, as a matter of urgency, review the regulations so as to allow the judiciary to deal with judges' leaves. Court infrastructure, which was raised by my colleague, at most of our courthouses is in a terribly poor state of affairs, which not only undermines the effective and efficient delivery of justice, but also creates the impression of a dysfunctional judiciary to the citizenry and the outside world. Let's be frank, the Department of Public Works has failed your department abysmally, Minister, in respect of maintaining our court infrastructure. The Durban High Court is a case in point. I raised this issue in a previous debate on this vote a few years ago. Some progress has been made. I believe tenders have been invited. However, delays still persist. Minister, we must think outside the box. The court was built in the city center, probably 100 years ago, when social engineering was the order of the day. Recently, I drove to the Durban Magistrates Court building, which has a great deal of additional space and infrastructure, and I struggle to see why the high courts have not been, at the very least, temporarily relocated to that precinct, because there's a lot of accommodation there, a lot of space there, and possibly you could build a brand new high court in the Magistrates Court precinct and use the current court, which was built 100 years ago, as a museum or something like that. Honorable Chairperson, the IFP also believes that judicial capacity is a cause for concern. In South Africa, we have approximately 250 judges responding to the needs of a citizenry of more than 58 million people. Surely this is woefully inadequate, and again alludes to the fact that the vast majority of our citizenry will not be able to access justice which they are entitled to. Justice will not only be delayed, but it will be denied to the majority of South Africans. But it will also make justice expensive. I just saw an account which I received on behalf of party, Honourable Minister, where a senior counsel billed for reserve for hearing. Didn't appear, didn't do nothing but 40,000 rand. Now, how many people can afford that kind of money? So there has to be some capping of legal fees, because it'll be out of sync for ordinary people, ordinary citizens, to access justice. Chairperson, security at courts is another challenge. We have noticed that the Chief Justice has, on numerous occasions, lamented the poor security that is provided at our courts. Judges in our courts are expected to be protected by private security personnel armed only with batons. Appropriate measures must therefore be taken in this regard. In respect of administration, I think my other colleagues have mentioned this, and specifically digitization of our courts, and with the advent of the fourth industrial revolution upon us, modernization should be made a priority. More resources must be made available with the requisite skills transfer and training so as to move from paper to digitization in our courts. Honorable Chairperson, and thank you here, Minister, in respect of the Land Claims Court, we believe that there are some moves for amendments to the Restitution of Land Claims Act to ensure that permanent judges can be appointed to the court. The inability of government to deal effectively with land claims submitted way back in 1998 has created unnecessary tensions, fears, and expectations. The IFP will support this budget, Honorable Chairperson and Minister, but we believe the independence of the Office of the Chief Justice and the judiciary must be maintained. I think you know about the Pied Piper of Hamelin. He who pays the piper calls the tune. And we don't want the department to call the tune.
The Honourable Member
Chief Justice
Singh.
should do that. Thank you.
Thank you very much. I now call on the Deputy Minister of Justice and Correctional Services, responsible for justice and constitutional development.
Thanks very much, Honourable Chairperson, Honourable Minister, members of the Judiciary, both from the higher and lower courts that are here, Chair of the Portfolio Committee and members of the Portfolio Committee, Honourable members, Secretary General of the Office of the Chief Justice and other heads of entities within the Justice family, ladies and gentlemen. The budget and the programme we present today underscores government commitment to access for all and the advancement of the rule of law. Our magistrates' courts and our magistrates have transformed dramatically since the dawn of democracy. Today, our magistrates' courts are legitimate, accessible, and serve everyone. From formerly being public servants, today our magistrates are independent judicial officers, and we're working towards amending the legislation and regulations that may still impede on their independence to further align the magistracy as far as possible and feasibly with judges. The Constitution's 17th Amendment Act and the Superior Courts Act paved the way for the transformation of the magistracy and its full integration into the judiciary, effectively making the 17th Amendment the Chief Justice, the head of the judiciary, and the Superior Courts Act making judge presidents responsible for the, or judge presidents of provincial divisions responsible for the magistrates in their provinces. We are finalizing a replacement bill for the Magistrates Act of 1993 that will enable us to consult with the Chief Justice and other stakeholders, whilst a replacement bill for the Magistrates Court Act of 1944 is still work in progress. There have been continuous engagements with the lower court judiciary on some of the policy choices that must be incorporated into the proposed bills. Part of the legislative changes seek to streamline disciplinary processes in respect of magistrates. Currently, the Magistrates Act requires both the National Assembly and the National Council of Provinces to pass separate resolutions as to the removal or non-removal from office of a magistrate. This can be problematic if the two houses do not concur in their views on such a decision. Now, when it comes to judges, it's only the decision of the National Assembly that is required. So surely there can't be any justification for a higher standard for the removal of magistrates than that of judges. And I think these are some of the changes that we need to make. The same grounds for removal from judicial office set by the Constitution for judges should also be made applicable for the removal of magistrates. I want to take the opportunity to formally bid farewell and thank Judge President Lachodi, the Judge President of the Mpumalanga High Court, who served the Magistrates Commission as chairperson with distinction for just over 8 years when his last term expired earlier this year. The President, in consultation with the Chief Justice, appointed Deputy Judge President Ledwaba, Deputy Judge President of Gauteng, with effect from, I'm told, 1st of April this year, for a 5-year term, and we wish him well with this additional responsibility, and Judge Ledwaba is in the gallery. Honourable members, during the 2018, the last financial year, the former minister, after consulting with the Commission, appointed 176 magistrates, 1 regional court president, 1 chief magistrate, 26 senior magistrates, and 46 regional magistrates. The Commission also advertised 349 posts of magistrates, and the recommendations of the Appointments Committee will serve before the full Commission later this month, now that both the National Assembly and the National Council of Provinces have designated their members of Parliament to serve on the Commission. These permanent appointments will further strengthen the work of the judiciary. It would be remiss of me not to convey our appreciation to the Commission in taking proactive steps in the filling of these, as well as other vacancies that have since been advertised. Where our magistracy was formerly overwhelmingly white and male, we've made significant inroads towards establishing a magistracy that truly reflects the demographics of our country. As of May this year, we had 2,007 magistrates across the country. 49% are African, 30% are white, 11% are coloured, 10% are Indian, and in terms of gender, 46% are women. And it's not just the total number. If you take the regional court presidents, there are 9 of them. 1 is on suspension. Of those in active service, 4 are women, 4 are men, and the person who's acting in the place of the person who is suspended is also a woman. So effectively, you've got 5 out of 9 regional court presidents being women. And then with the chief magistrates, it's a similar high representation of women in senior positions. Budget vote debates give us the opportunity to get a holistic view of all the many different components and various role players within the justice system. It also provides an opportunity to reflect on successes and identify areas which demand more attention. So it's rather pitiful that the DA's so-called shadow Deputy Minister of Justice was given an opportunity to speak in the justice budget vote debate this morning, but instead of focusing on important justice matters concerning our courts and country, he decided to play the man and not the ball, half his speech in fact. In the 5th Parliament, this is not unusual. In the 5th Parliament, his main contribution to debates would be to personally attack me on occasions like this. He seems to think that as shadow Deputy Minister, he must attack the Deputy Minister. Or perhaps he simply has nothing of substance to say. And I expect that his contribution to this debate will be no different when he speaks later. I'm not sure why the DA gave him a shadow position. A shadow can only exist when light falls on an object. But the Honourable Horn is completely in the dark when it comes to the correct facts, and he showed that earlier today. Chairperson, the State of the Nation address obliges us to commit ourselves to building a capable, ethical and developmental state. This includes well-functioning and accessible courts. The Chief Justice controls the judicial functions of the superior and lower courts, whilst the Department of Justice continues to support the administration of the courts. The Chief Justice's norms and standards provide that the Chief Justice is responsible for the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts. This consequently includes monitoring the performance of the courts. And I think we've had in the debate 2 different perspectives. We've had Honourable Breitenbach's, we've had Honourable Singh's relating to the issue of accountability for this. And I think it's important that those issues, 2 different positions have been raised, and I think we need to reflect on them and we need to debate them. The latest Victims of Crime survey done by Stats SA shows that South Africans are less satisfied with the courts than they were last year. When asked for the reasons as to why they were not satisfied with the performance of courts, many felt that matters dragged on for too long. Which brings me to the issue of backlog courts. The number of outstanding and backlog cases, in other words, those taking longer than 6 months in the district courts and longer than 9 months in the regional courts, are increasing in the lower courts. This leads to delays in the finalization of cases and the increased overcrowding of prisons. In this regard, it would be important to engage the judiciary on measures that we, the department and the judiciary together, along with other role players like the NPA, Legal Aid South Africa and the legal profession could implement to raise confidence and trust amongst members of the public in our courts and to improve the optimal functioning of our courts. We all have a role to play in making the courts work better and more efficiently. We're therefore heartened that the Office of the Chief Justice has indicated that it will ensure strengthened and structured stakeholder dialogue and collaboration during the medium term. This will be achieved through, amongst others, committees such as the National Efficiency Enhancement Committee and the Provincial Efficiency Enhancement Committees, which contribute to enhanced efficiency and the performance of the courts. Part of the reason for court backlogs are blockages in the system, such as infrastructural challenges, including power cuts, water shortages, equipment issues, and so forth. However, most disconcerting is the lack of a staff due to continuing budget cuts as a result of the fiscal constraints that we're facing as a country. This impacts not only on the departments, but also on the Prosecuting Authority and Legal Aid South Africa, requiring our department to then reprioritize its already constrained budget to try and assist where we can. Budget cuts have had a negative impact on the filling of court staff-related vacancies. One of the measures we're currently investigating is the correct staff capacitation and placement in relation to courts through an analysis of the workload and court staffing available. But some courts only are sitting 1 or 2 hours a day, and this may require, for optimal efficiency, the combining of court roles in a court centre. The functioning of periodical courts is also being looked at. Just to Honourable Breitenbach, there are a number of courts who are sitting over the 4.5 hours of the norm, but it's not enough. That is meant to be the standard that is followed, and it's not being followed. The standard set by the Chief Justice. Honourable members, the National Development Plan urges us to build a society where all persons are and feel safe. This means that we need a criminal justice system that works and works well. Notwithstanding the challenges mentioned, the conviction rates of those cases that are enrolled in the lower courts are indicative of a functioning system. All criminal courts, for example, managed to obtain a 94% conviction rate. High courts achieved an 89% rate. Regional courts, 81%, the highest rate in the past 5 years. And district courts, a rate of 95%, exceeding the target by 2%. As the Minister has indicated, the Department embarked on the rationalization of magistrates' courts and aligning the jurisdiction of magistrates' courts with municipal and provincial boundaries so that communities can obtain legal redress and access justice services nearer to where they live. All the provinces have been aligned with the exception of the Eastern Cape and KwaZulu-Natal, where consultative processes are still ongoing. The aim is to finalize this during the current financial year. With regards to the alignment of magisterial districts with high courts, the alignment of divisions of high courts with provinces for Gauteng, Northwest, and Limpopo were completed. Honourable members, the South African Judicial Education Institute was established in order to promote independence, dignity, and the effectiveness of the courts through continued judicial education. In responding to the goal of the Office of the Chief Justice for improved administrative and technical support to the judiciary, which contributes to ensuring an efficient court system, the Office of the Chief Justice continues to provide support to the South African Judicial Education Institute with the facilitation of 142 judicial education training courses covering over 3,000 delegates in the period under review. The training courses conducted include court annexed mediation, case management, children's court skills, criminal court skills, family court skills, and civil court skills, competition law, maritime law, judicial management, and judicial ethics, as well as environmental crimes. These training courses are crucial in that they contribute to the provision of quality justice for all. And SAJE has also contributed to the judicial training in the SADC region. And they've judges have been involved in the training of traditional leaders. Further to these reported achievements during the current financial year, as targeted in the annual performance plan, SAJE will facilitate a total of 80 judicial education courses and will also be training the 249 newly appointed district magistrates who will be appointed later this year. We must capacitate SAJE to ensure it can continue to deliver on its mandate as articulated in the National Development Plan. Chair, justice means making sure that people are heard when they go to court. Justice means giving people hope in the belief that they will be treated fairly and reasonably and with dignity. Justice means the protection of rights and conviction of wrongs. Our magistrates' courts continue to be the first port of call for access to justice for most people, with over 700 courthouses countrywide. For this reason, we meet regularly with the Regional Court Presidents Forum and the Chief Magistrates Forum, and we thank them for the good working relationship that exists between the magistracy and the department. 77 of our magistrates are serving as commissioners in the small claims courts. These magistrates offer their time and expertise free of charge and after hours to assist in this important task. This assists us immensely, particularly in small or rural areas where, if it were not for a magistrate serving as a commissioner, we would possibly not have been able to have a functioning small claims court there. For a court to render a service, it must be supported by judicial officers who are committed to serve the public and the cause of justice, in particular the needs of the poor and the most vulnerable. Often our magistrates are at the very face of the law, and our magistrates' courts are at the forefront of people's interaction with the law and the justice system. We are unwavering in our commitment of support and capacitate these courts. Thank you.
Thank you very much, Deputy Minister. I now call on the Honorable Essen Swart.
Thank you, House Chair. The Office of the Chief Justice and the Judicial Administration was established primarily to support the Chief Justice in executing his or her administrative and judicial duties as head of the judiciary and head of the Constitutional Court. And the ACDP wishes to commend the judiciary and the OCJ for the support that it provides. The judiciary have not wavered in holding the executive and even Parliament to account and has been a bulwark against state capture and reckless executive decisions. And we from the ACDP side are fully supportive of courts holding ministers and officials personally liable for legal costs caused by reckless political decisions, such as the SASSA pension and welfare grants scandal. Chairperson, the OCJ has allocated an annual budget of 2.3 billion for this financial year. And the ACDP shares concerns expressed by the committee in its report that it and the judiciary, in fact, is underfunded. And we've heard of dilapidated courts. We've seen a shortage of tools of trade, such as law reports, and this, in our view, is unacceptable. Chairperson, the ACDP also understands that the Secretary General was not able to respond to certain queries during the briefing to the committee relating to court performance, as this lies in the domain of the Chief Justice. Now, members of the previous Justice Committee who attended the Chief Justice's briefing in this regard in November last year also felt at that occasion that there was insufficient time to engage with the Chief Justice on these and other matters of mutual concern. The recommendation was then made that through the Speaker's office that the Portfolio Committee and Parliament should meet with the Chief Justice and the heads of court. And this has been a practice over the years. And this recommendation was accepted by the committee, and we look forward to such meeting taking place before the end of the year. We would like to add that members of the representatives of the magistracy should also attend that meeting. Now, a further matter which should concern all of us in Parliament and serving in this committee in particular is the delay in amending laws which the Constitutional Court has found to be constitutionally wanting and sent back to Parliament. Following such a judgment, the relevant departments propose amendments which Parliament must then pass within a specified time limit. However, there have been inordinate delays from the executive side, which places enormous pressure on Parliament. And in certain cases, certain departments have approached the court for an extension of that time, and that extension has been refused because the department, in the view of the Constitutional Court, has not done enough to propose amending legislation. However, one needs to remember that the court order was given against Parliament to remedy that legislation, and it is Parliament that would then seem to be non-compliant with those court orders. And this is a matter that requires Parliament closely to exercise oversight over the departments, as it would not be good for Parliament to be seen in contempt of court through no fault of its own. Chairperson, lastly, the ACDP would like to thank all those members and officials involved in the judiciary in both the higher and lower courts who dispense justice on a daily basis, often under very trying and difficult conditions. It is much appreciated. The ACDP will support this budget vote. I thank you.
Thank you very much, Honourable Member. The Honourable Member Mohammed.
Thank you very much, Honorable House Chairperson, Minister and Deputy Ministers, esteemed members of the Judiciary, honorable members, distinguished guests. The African National Congress supports the Budget Vote 22 of the Office of the Chief Justice. Chairperson, the freedom we enjoy today was achieved through struggle, determination, and great sacrifice. And by working together, we will be able to strengthen democracy, continue the drive towards access to justice, and a transformed justice system. We are proud to be representing the organization that gave the world Nelson Mandela and who stood for the ideal of a non-sexist and non-racist society. In his inaugural address as the first president of the Democratic Republic of South Africa, President Mandela said, and I quote, "Let there be justice for all, let there be peace for all," unquote. This is what drives the work of the OCJ, to ensure that there is justice for all. Justice for all is intricately linked to the courts. Courts have to be independent, they must be represented and respected by the people and be ultimate guardians of the rule of law. Chair, as the ANC, we remain committed to maintain and ensure independence of the judiciary and to protect the courts to enable it to adjudicate cases without fear or favor. To further affirm the independence of the judiciary, the ANC-led government introduced the Constitutional 17th Amendment Act and the Superior Courts Act in the National Assembly. Both these pieces of legislation were enacted with effect from August 2013. And these two acts have fundamentally changed the landscape of our judicial system and our court system. Chairperson, the transformed judiciary has been one of the success stories of our constitutional dispensation. Let me, however, raise some issues for possible improvement. Firstly, regarding the tools of trade. As we heard earlier, it is known that some judicial officers are experiencing difficulties accessing tools of trade, especially library materials. The transfer of functions from the Justice Department to the OCJ that will allow the judiciary to access these materials for itself has not been finalized. Members will recall that the transfer of administrative functions, identified staff attached to the superior courts from the Department of Justice to the OCJ commenced on 1 October 2014, and the OCJ received its own budget vote from 1 April 2015, as pronounced earlier. We, however, welcome the Minister's pronouncement in his input earlier that this will be finalized soon. Secondly, a matter which is of vital importance, Chairperson, is the implementation of the judicial norms and standards and how this has an effect on case flow management, judicial officer caseloads, and the availability of up-to-date statistics on judgment reserved for longer than 3 months across all courts. The norms and standards, the directive issued by the Chief Justice in February 2014, Chairperson, provides timelines for the finalization of cases, and we are confident that the judicial officers will strive to finalize cases within the time period and do so as expeditiously as possible. The coordinating committees, also known as efficiency enhancement committees established by the Chief Justice to facilitate improved case flow management in all courts, including the lower courts, are now in place, we understand, and operational. And we therefore welcome this initiative by the Chief Justice in addressing court blockages. We are also pleased that the OCJ plans to further improve the quality of its performance information by implementing an automated system to monitor court performance, which in addition to the electronic filing system for superior courts, is expected to simplify the monitoring and evaluation of norms and standards. Chairperson, if we are to gauge properly how well the courts are working, we will need clarity on how best to access court performance information. Whilst it is understood that court performance entails the involvement of a number of role players, we are aware that solution lies partly in the finalization of the long overdue court administration model. And therefore, we are looking forward to the process that will be followed to reach consensus on a court administration model, a process we are sure will be suitable to our constitutional dispensation. Finally, Chairperson, the passing of progressive pieces of legislation is a key function of this 6th Parliament. We are therefore excited about the Minister's announcement and plans to present a draft land court bill, which would strengthen adjudication of land restitution, expropriation of land, and ultimately land distribution. and that will also ensure that judges are appointed permanently to such a court and its proper capacitation. Honorable members, later this week, we will be celebrating Mandela Day. Madiba taught us never to rest on our laurels. In his book, Long Walk to Freedom, he says, and I quote, after climbing a great hill, after climbing a great hill, one only finds that there are many more hills to climb, unquote. Much has been achieved in the area of providing justice and justice services to our people. But Chairperson, we cannot rest, for there is still so much more that needs to be done. I thank you.
Thank you very much, Honorable Member. I now call on the Honorable Imam. Order, members.
Thank you, Honorable House Chair, Minister, Deputy Minister, our colleagues here from the judiciary, our honorable members in the House and members of the gallery. Allow me first of all to congratulate the Minister, the Deputy Minister of your reappointment and your team.
Order,
The National
Honorable
Freedom Party
Kaula.
welcomes the report of the Department of the Office of Chief Justice and Judicial Administration, vote 22, tabled here today. We also welcome the measures that the department is putting in place, particularly with the different causes that you are planning to put in, particularly with the criminal court skills, the Chief Justice skills, and I think very importantly, the domestic violence and the spousal and child maintenance, because I think we have a lot of weaknesses there particularly. So I'm glad that you're putting in some measures in terms of that. But some of the weaknesses or challenges that we've identified as the NFP, first of all, is the issue of postponements. Now, particularly in the lower courts, you get postponement after postponement, and it's at exorbitant cost, particularly to the victims. They have to repeatedly, and legal costs in South Africa today is not cheap. Lawyers or attorneys today are actually milking the clients, and it's become a kind of a business, a ruthless business, to be very honest with you. So I think that's one of the problems that we've identified. The other thing is I think there needs to be a greater coordination or effort between the Department of Justice, the South African Police Services, and things, because and correctional services, of course, because there appears to be, and this is what I've identified in discussions with some of them, while the police have the responsibility of pushing to arrest people and put them there, the courts are there trying to just get them off the roll. And very often what we find is that, matters are being struck off the roll and things, and I think we need to look at that in terms of the challenges that some of our people are facing. The other problem that we have, particularly in the lower courts, and I think I'm coming to the issue of the maintenance courts and things, there appears to be some kind of, well, there are serious allegations of collusions, particularly, not only in maintenance court, but particularly when it comes to after-hours bail and things. What is actually happening is there is this link between prosecutors who are giving after-hours bail together with police officers and with attorneys, and that is why you would find on certain matters people are arrested hours later, they are given bail, and then the police have done their work, but what is happening at the end of the day? People are out on the streets again, people are now reluctant, and they don't want to go back and actually report these cases because they feel it's a wasted exercise. So I think it's another matter that we need to look at. Okay, added to that is the other problem that we found is the assistance that victims get, particularly in the lower courts. Again, when it comes to issues of maintenance and things like that, what we found is that absconding fathers, and I think we have some in the house, they either don't want to pay or they run away from city to city, and the officials are not assisting. Maybe it's probably not too much in their mandate, but to be able to assist to bring these people from the different cities that they're running away, to be able to get them work in collusion with courts in the other cities, to be able to identify them and bring them to book, because otherwise these, particularly the women for the maintenance of the children, have to repeatedly run to court. And it seems to be a serious
The Honorable
The
Member
National Freedom
Imam.
Party supports this and welcomes it. Thank you very much.
Thank you very much. I now call on the Honorable Hon.
Chairperson, an independent judiciary is part of the lifeblood of any constitutional democracy. Justice Rezine Mzika-Manda, Judge President of the High Court of Malawi in 2007, in an article entitled "The Place of the Independence of the Judiciary and the Rule of Law in Democratic Sub-Saharan Africa," identified certain essential elements of judicial independence. Of these, we are happy to say the following elements are present in South Africa in a more or less uncontroversial manner. The constitutional guarantee of judicial independence, a transparent and fair nomination process of judicial officers which is sufficiently insulated from political interference and which is aimed at ensuring impartiality and integrity, security of tenure and remuneration, and impunity from the prosecution for the content of judgments. However, Chair, two of the elements identified by him as vital to an independent judiciary have not been resolved yet in South Africa. Firstly, administrative and budget autonomy. The establishment of the Office of the Chief Justice as a separate government department was, at the time, seen as a step in the direction of establishing administrative and budget autonomy for the judiciary. During the Fifth Parliament, however, this issue was not, as it should have been, settled. For all intents and purposes, we had a standoff between the executive and the judiciary on this issue. Minister, unfortunately, if one thinks about your predecessor and how he dealt with this issue, the following words come to mind: obstruction, obfuscation, avoidance, and retardation. Of course, he was assisted, and not really in an able manner, might I add, by his deputy, which is now, of course, your deputy. To shed some light on his woeful record as part of the executive of the Fifth Parliament, let me remind this House what the Chief Justice said in November 2014 at INISA. He said at the time that the judiciary was confronted with unbelievable resistance by the executive, of which this Deputy Minister was part, a hostile fight to keep the office of the Chief Justice a satellite office of the Department of Justice. So, Chair, while this Deputy Minister thinks this debate is about contributions in the Fifth Parliament and found time to evaluate mine, let me assure him that I'm very glad that my legacy from the Fifth Parliament does not include attempts to resist and frustrate judicial independence. This is, of course, in addition to him coming out a week after the Constitutional Court held that his favorite president, former President Zuma, failed to uphold the Constitution, trying to defend the indefensible by saying the president's violation of the Constitution was not that serious. Now, Honourable Minister, every year during these debates, the finalization of the court administration model was put on the back burner by your predecessor by announcing further research and consultations, future colloquiums, cabinet committees on the issue, pending cabinet decisions, none of which were ever heard of again in the time between the budget debates. We note your statement today that you will soon take this matter to cabinet. Minister, please don't be that kind of a minister. Finalize this matter. Chair, as in the past, we confirm our stance that to enhance the independence of the judiciary, we are in support of a judicially led court administrative model in which the judiciary is not dependent on either the executive or the legislature for the budgetary appropriation that is to be entrusted to it. The other matter, not resolved yet in South Africa, and which Justice Mzika-Manda identified as essential to judicial independence, is that of judicial accountability. A judicially led court administration model does not mean that the judiciary is not to account for the manner in which it administers its budget and the manner in which it self-regulates in respect of all matters other than the contents of its decisions. This legislature, Parliament, has been found wanting, and rightfully so by our courts, over the last few years for not properly performing our duties of oversight and not properly holding to account the executive. The source of our oversight duties, colleagues, and our functions is, of course, to be found in our constitutional duty to oversee the manner in which public money is spent by every institution to whom it has been entrusted for the performance of a public function. Chairperson, therefore, a system with which all branches of government are either equally happy or unhappy with will have to be developed to ensure that the judiciary not only account for the money it receives from the public purse, but also for the operational standards one can reasonably expect of an optimally functional judiciary. it must follow that while the tenure and remuneration of individual members of the judiciary is an inalienable right in South Africa, as with all other rights, it brings with it responsibility. In this case, the responsibility of the judiciary having to deal with the thorny issue of administering discipline in the case of allegations of misconduct against their own, not only in a fair manner, but also in a speedy and final manner. Judge President Mzika Manda, in the article I referenced, states that public confidence in the judiciary is yet another important element of its independence. The uncertainty around the failure to finalize the decade-old complaints against Judge President Klope and to bring to finalization the matter against Judge Mutata, after his disciplinary hearing was concluded in January 2018 already, and the tribunal found him guilty of misconduct in April 2018 already, creates the very real possibility, unfortunately, that public confidence and trust in the judiciary could be broken down. This is very dangerous, because the authority of our courts are grounded in, amongst other things, confidence on the part of the public that the judiciary is earmarked by integrity and impartiality, and that it displays moral authority. Chair, we know that the Chief Justice is in agreement with us. Last year in November at the Judicial Accountability Session convened by him, he stated, and I quote, "Lack of confidence in the judiciary has the potential to erode the moral authority of the judiciary. We as the judiciary do not control the army, the police, or the public purse. Our orders as the court are obeyed because of the moral authority we enjoy. If we lose public confidence, we are finished. Therefore, Chair, in conclusion, the only thing that remains on the issue of self-discipline is for form to now follow function." I thank you.
Thank you, Honorable Member. I now call on the Honorable Newholt Drachen.
Honorable Chairperson, Honorable Minister and Deputy Minister, honorable members seated here today, visitors in the gallery, all protocol observed. Honorable Chairperson, I would like to congratulate all of us who have made it here to the 6th Parliament. I hope that we all will all work together to better the lives of our people. During this month of Tata Nelson Mandela, I would like to pay tribute to those who came before us, to those who are still here with us, who fought and gave their lives to the struggle for a non-sexist, non-racist, democratic South Africa. The Office of the Chief Justice was newly established as a national department proclaimed by the President of the Republic of South Africa in August 2010. The objectives of the OCJ include the following: to ensure that the Chief Justice can properly handle his mandate and that of the Constitutional Court and the judiciary; to enhance the institutional, administrative, and financial independence of the OCJ, as well as to improve organizational governance and accountability to effectively and efficiently use resources. Over the medium term, the South African Judicial Education Institute, also known as SAJE, plans to provide 246 judicial educational courses, including case flow management and constitutional imperatives. Other planned courses include courses on record keeping, general issues and pleading, debt collections, and debt reviews related to the National Credit Act of 2005, as well as criminal court skills, child justice skills, new legislation on domestic violence and spousal and child maintenance, immigration, and other topics. Expenditure in the SAJE sub-program is expected to increase from 51.4 million rands in 2018-2019 to 53.8 million rands in 2021-2022. Honourable Chairperson and Honourable Minister, I would like to highlight the following matter. In the United Nations Convention on the Rights of People with Disabilities, Article 13, under Access to Justice, in Clause 2, states that in order to ensure effective justice for persons with disabilities, state parties shall promote appropriate training for those working in the field of the administration of justice, including police and prison staff. I would like the Minister to know that we in the deaf community are very concerned about the lack of access to justice for deaf people, whether they are criminals or victims. This includes young deaf children and deaf women who were either sexually molested or raped. And it also includes the lack of access to lack of quality access, rather. What I mean by this is the lack of South African Sign Language interpreters. And when the court says sign language interpreters are available, those interpreters are not competent enough to interpret in the court environment. Therefore, for the deaf person appearing in court, they will not understand the proceedings because the court interpreters are appointed without the consultations of the Deaf Federation of South Africa or similar organizations who work with the deaf community. I am appealing to the Minister and to the Chief Justice to put in place training programs, to provide training programs for the judiciary about the deaf people, South African Sign Language, deaf culture, as well as sensitivity training regarding people with other disabilities who may also be victims or criminals and also need access to justice. There are currently 2 cases, one in the Eastern Cape and the other in KwaZulu-Natal, where there are deaf people awaiting trial, and their court cases are continuously postponed because of a lack of sign language interpreters, or the sign language interpreters are just not available. I also note the concerns raised by the Pan-South African Language Board about the continuous exclusion of historically marginalized South African indigenous official languages by the courts. I also note that the CEO of PanSalb has been trying to get together the heads of courts in order to solve the issue of the language used in courts. I hope that the Minister and the Deputy Minister will assist in addressing this issue. In keeping with the 4th Industrial Revolution, the Office of the Chief Justice plans to modernize and digitize its systems and processes in order to respond to the growing need of court services and also to stay abreast of technological developments. The implementation of an electronic filing system for the superior courts by 2020-2021 is intended to increase efficiency. And the project that forms part of the Integrated Justice System programs led by the Department of Justice and Constitutional Development in the Justice, Crime Prevention, Security Cluster. An amount of 14.3 million is allocated over the medium term for the system in the administration's program. Further, the OCJ plans to improve the quality of its performance information by implementing an automated system in order to monitor court performance. And in addition to the electronic filing system for superior courts, is expected to simplify monitoring and evaluation of the norms and standards. Digitizing automating systems will assist in minimizing crime, coordinating information about citizens and government services in the justice cluster. Chairperson, I'd now like to use this moment to talk about the information regulator. The Protection of Personal Information Act of 2013, also known as POPIA, regulates the processing of personal information by providing a framework that sets out the minimum standards that responsible parties must comply with when processing personal information. The information regulator has been established in terms of Section 39 of the POPIA, and it has a wide range of powers and functions relating to the promoting and enforcing of the right to privacy. Currently, only parts of the Act relating to the establishment of the regulator and making regulations are operational. Once the regulator is fully operational, the remaining provisions will come into force. The committee is of the view that the establishment of the regulator is a priority, and unless the regulator is fully capacitated, the remaining provisions of POPIA will not be declared operational. It is important in South Africa that there is a legislative framework that protects personal data. The committee thus urges that the minister urges that the delays be addressed urgently, and that the minister assists the information regulator in its engagements with the Minister of Finance and National Treasury to find a solution as soon as possible in the matter of the information regulator's organogram. The budget provided to the regulator is 28.9 million in 2019-2020 and 30.5 million in 2020-2021, with 32.2 million in 2021-2022. And the information regulator will be tasked with approving and implementing the following: the Public Awareness Strategy Plan, the Communication and Branding Strategy, the Stakeholder Engagement Strategy Plan, the Guidelines for Codes of Conduct, the Guidelines for Registration of Information Officers, as well as implementing the Memorandum of Understanding between the Information Regulator and the South African Human Rights Commission. The committee notes that the South African Human Rights Commission will continue to fulfill its largely unfunded mandate with regards to access to information until the regulator is fully operational and the remaining provisions of the POPIA can come into effect. With that, Honourable Chairperson, I would like to announce that the ANC supports this budget vote. 22. I thank you.
Thank you, Honourable Member. I now invite the Honourable Minister of Justice and Correctional Services to respond to the debate. The Honourable Minister.
Thank you, House Chairperson. Valaudzi rotakalanga manda zino. Vodana speech sichona sha hey session. So zino recover tangana zanaborin. Thank you very much for the constructive inputs from all the members of the committee. We have listened and heard your views on various issues, which I think the norms and standards that the Chief Justice has released with regard to the administrations of the justice system and the various bodies that he has created respond to some of the issues with regard to time of the courts, with regards to the judgments and the various issues. But obviously we need further engagement to enhance the efficiency of the system. With regard to the interpreters, as mentioned for the deaf people, I think the department will have to look closely at this matter because it's a matter of serious concern, which will help us in terms of access to justice for all South Africans. The maintenance of our courts, it's a serious concern that has reverberated on all speeches. And I think in the first session earlier today, I've already said that we have piloted a project with correctional services at the Middelburg Magistrate Court and the High Court, which we are going to use going forward to help us on our various courts across the country in terms of maintenance and also in terms of refurbishment of some of the old age infrastructure of our justice system. Lastly, I want to thank the Office of the Secretary General of the Chief Justice for the help on this process up until today, and the members of this committee and their constructive input. I will not be able to go through each and every speech, but we will respond to it through action and some of it through words of mouth as we move forward. Thank you very much.
Thank you, Honourable Minister. Honourable members, that concludes the debate and the business of the day. The mini plenary will now rise.